Hello. Wait, I'm not doing this anymore. Hold on. All right. Hello there. Let me go here. Hey. Welcome to History Chats this afternoon. Yeah. It's a new month. We have a new theme, as we try to do. This is kind of the odd one of the month, but well, actually, I can show the graphic for the month. We're kind of doing sort of a civic lessons sort of thing. We're looking at different aspects of government and representation and things like that. So today we're talking about a specific law and how it affects things here in Marathon County. But for the next couple of weeks, we're going to be talking more about some different aspects of our representation and the way that things work in local government, which on the surface, you may kind of have an idea, but we're going to try to make it interesting and, use some local stories to kind of springboard a discussion about those. So it's an interesting concept. Hopefully, you find that interesting. Yeah, before I get into this one, though, I just want to make a point of saying this weekend, just in a few days here, if you're watching this close or at the day this comes out, we have our next History Speaks, so it'll be this Saturday at 2 p.m. on February 4th. And that's going to be, Vern Pickering is going to be coming and talking about his research into this guy here, whose name I have not quite remembered specifically, but he is a member of the Chippewa, or the Ojibwe people, and an Episcopal pastor, and a really interesting figure, kind of bridging sort of the Native American experience into the 20th century. And Vern has written a book recently about this, and he's going to be sharing that experience with us. So it's going to be an interesting program if you're looking for something to do this Saturday. We'll be doing that, and probably we'll be recording it, and then there'll be a video that comes out probably later the following week. Yeah, so just wanted to let you know about that. But today we are talking about an interesting little law. No, not a little law, a pretty important law, which is the workers' compensation law that Wisconsin passes in 1911. Yeah, I'm just going to double check that everything. Great, good. This is a fairly interesting law. So you might be familiar. Oh, and I'm just going to make a point of saying, I wasn't sure if I was going to put this in, but anyway, this is, I actually here. So I am not a lawyer or someone who's gone to, understanding, but I did read quite a few books, primary resources, well, secondary, I guess, about law and workers' compensation insurance. A lot of this stuff came out of the former Wausau Insurance library. And this was just a fun cover that I'm going to, borrow for the program here. Anyway, Wausau Insurance is actually a good place to start because chances are, if you're from Marathon County or Wisconsin, maybe one of the things you might be aware of, but fun bit of trivia is that Employers Mutual, which later becomes Wausau Insurance, actually has the distinction of issuing the very first policy under the oldest workers' compensation law in the country, which is the one that Wisconsin passes in 1911. This is the cover of a policy that was put together for the Wausau Sulfite Fiber Company, which is Mosinee paper. It's the original name. They're going to change the name over the next few years. But yeah, the very first policy issued by Employers Mutual for Mosinee paper is considered the very first policy under what is the oldest law in the United States. In the United States, unlike other nations, which are maybe more centralized, we have sort of a decentralized system for labor laws, which is to say that for the most part, the federal government doesn't have a lot of say in setting things like minimum wage or workers' compensation or things like that, but instead the individual states tend to make their own policies. Now, of course, the federal government does have some authority to set those sort of policies for federal employees and, regulating things across state lines. But generally speaking, you won't see like Congress or the President of the United States signing a law that, that Congress sent him or her about, these sort of things. And so it's up to the individual states. And often when a good idea comes around, it starts to, filter around, and it's easier if there's a consistent system throughout multiple states. So that's why Wisconsin has the distinction of being having the oldest in 1911. But I think that what is really interesting about this is not just the Employers Mutual side of things, the Wausau Insurance. And certainly, if it wasn't for this law, we wouldn't have the company that has given, the Marathon County communities, a lot of, people have worked or used to work for the company. You have very interesting branding, the depot logos and things like that we've used for years. 60 Minutes commercials, whatever Wausau Insurance from, that would not have been possible if it wasn't for this law. So I thought, okay, what is this law and where does it come from? And it's actually kind of interesting. So the law actually replaces something called the common law system. Well, it's not really a system. At its basis, common law is essentially a body of laws that are based on court decisions and the precedents they set, rather than a statute or codes or ordinances that are passed specifically. So to put this into terms, and I don't know if this is going to land with people, but I'm going to do it anyway. And then as posited in the 1997 Disney film Air Bud, turns out that there are no rules that a dog can play basketball, right? So, hey, why not? Now, in reality, the reason for that is when they came up with the rules of basketball, they probably didn't expect that someone would be, sending a golden retriever in. And so they never made a rule against it. And maybe we don't need to. I mean, to this day, even after the success of the Air Bud franchise or whatever, the NBA doesn't explicitly have a rule saying, hey, you can't, the Milwaukee Bucks are not going to be starting maybe they could even start a Great Dane or something like that on, at the next game. Informally, I've looked into it a little bit just out of curiosity. Apparently, there are some rules that say, for example, all players have to be at least 1 year removed from high school and have to have a degree. So in this case, the dog would have to have gone and get a high school degree. But I guess, I don't know, a lot of complications. But you get the idea here, right? Nobody is saying at the beginning of the outset of this, hey, let's make a law that says X, Y, Z. But that doesn't mean that there isn't implicit or understandings. You could extend other laws that are already on the books, like the high school diploma and sort of age restrictions to say this dog doesn't fit that. And so you could effectively say it would be illegal for the dog to play basketball. And I think I'm just going to leave the analogy there. We'll talk more about this. So basically what this means is that instead of setting a law in there, it's basically a system that emerges kind of almost organically. So one thing that we should, understand is that expectations are that everybody should assume that an employer can't harm their employee. They can't, hurt them. And they must be responsible in the way that they direct, like, here's what I'm asking you to do, and the expectations for the employees. If you're unreasonable, and that causes harm, that's probably not good. If the conditions are, I'm working in a factory and there's poisonous gas coming out, that's not something that should be okay. So if I get hurt, the expectation is there's a level of liability that the employers should be meeting. And then the question becomes, have they failed in that expectation? And if they have, the understanding then that emerges in the 1800s is that an employee should be able and should sue their employee or employer, the people that hired them, if they violate those things and they get hurt. What this typically mean, and it's worth noting that this is not the universal thing. It's not like everybody who ever hires somebody goes through this sort of relationship. In fact, a lot of times in small communities, there's sort of informal sort of things that keep this from being an issue. If I am hiring, I have half a dozen people working for me in my store, and I screw over one of my employees who gets hurt, and I say, well, you're on your own, you're fired, I'm not going to help you. It's a small community. People will know that. People will remember that, right? And for the most part, people don't, it's hard to do that. Most people are human beings and they empathize and they understand that. But in the 1800s, increasingly, we are finding urbanized, industrialized life where people are living in huge cities, lots and lots of people. And, there are factories and companies in which the people that are owning it, that are making decisions and policy, they have very little connection or understanding or empathy for the people that are working for them. And so increasingly, we're seeing this situation where people are getting hurt and then they end up suing their employer. And that creates sort of a body of law through the precedent of these court cases that allows for essentially what happens if someone gets hurt at work, right? Now, there's some problems with this. One, for example, is that apparently in most states, now they do address this, but there was no right of action for someone who was killed. So yeah, if you get hurt, you can sue your employer. If you die, you're dead. You can't sue your employer. Now there were death statutes that were passed that did extend the right to, next of kin and dependents and that sort of thing. So, if my children or, my spouse is now having to deal with the ramifications of my death, they can sue my employer, right? The other problem that happens is this system, basically because the courts get set down the precedent, it creates a, what we would call a, so some options that basically make it really, really hard to actually win out if you have a case. So, for example, I've seen these. There's three of them. I've seen them called the unholy triad. I don't know if they used it at the time, but one of them is assumption of risk. Hey, you're trying to sue me because you got hurt at work. Well, you were hired to do a job that is inherently dangerous, and you knew that when you were hired. You took on that risk when you decided to work for me. So if it turns out that the job was dangerous, well, that's not my problem because you agreed to work this job that is dangerous. And this is something that, is difficult to overcome because, in some cases. There was a rule that said fellow servant. So yeah, you may have accidentally, had your hand put into a psalm and lost a couple fingers. Well, it's not my fault that there's not proper protection to stop someone's hand from going in there. It's Jim's fault because he was the one that bumped you and forced you, and caused you to lose your balance. And then that's why. So really, if you're going to sue somebody, it's not my fault. It's the guy who pushed you accidentally or intentionally or whatever. I'm not going to make that decision, but that's the guy, right? So shifting the blame to someone else, either in this case, another employee or you. Hey, if you had followed the sort of vague rules, or if you weren't in that position to get pushed into the saw, and I didn't tell you you should be there, well, then that's your problem. You went out of your way to be reckless or to do something that caused you to get hurt, and it's not my fault that I didn't protect against that. And these three make it really, really hard for employers to lose cases. They are able to shift the liability to someone else, and because the system is all about figuring out who's to blame, they're able to get away with, a lot. Again, not everybody, but enough people that it ends up happening. Also, this is just, from start to finish, a very expensive and time-consuming process, especially for somebody who's been hurt at work. So in theory, having the courts arbitrate who's responsible, who's at fault here, is it the employer or the employee? There should be an impartiality there. They shouldn't be able to say, oh, it's this person or this person automatically. But it's all law. It's all understanding these precedents in the court cases. So you have to have a good lawyer. Good lawyers are expensive. And when you think about who has the resources to hire good lawyers, the big companies, the people who have a lot of money because they own the company, it's a lot easier for them to do that. Whereas somebody working the floor of a factory, they don't really have a lot of recourse. And even if they do, even if they're able to overcome all of, these things, and they have a lawyer, it's going to take a while because it's got to work its way through the court system. And for somebody who is, maybe injured and can't work and maybe has dependents and family that they have to provide for, can you sit around for a few weeks or months or even years in order to get money that you need? And not, in many cases, no. Just to give you an idea, there was a study in 1908 that found that it took $81 spent just to get $18 to an injured employee using this system. So that's not great. And I also don't know how long this process would have taken on average. They didn't include that in the source that I saw. Also, just finally, again, not everybody feels like, not all employers are taking advantage of this, but it's ubiquitous enough that this system just makes all employers look bad. Maybe they genuinely want to help their employees, but the system for helping their employees means they have to implicit or explicitly, take on the negligence, the liability in order to do so. And that's not great. So having this system that lets them kind of, helps their bottom line by not having to pay compensation for people who gets hurt, that's great for employers. But increasingly, people are not happy with the way this works because it paints them out to be the bad guys. And, they don't always think of themselves as nobody thinks of themselves as a bad guy, probably. But it's not fair for most people in most employers. So for all of these reasons, there's kind of a dissatisfaction with the way that the system is working. And in Wisconsin, and I just threw up these two guys as too prominent. There's a lot of people that are responsible, but John Commons and Charles McCarthy are sort of civil servants, and they are working to try and look at the statistics. They look at the situation. They say, look, the deck is pretty stacked against employees who get hurt, and yet every year we are seeing more and more and more claims going to court. And that's not great because it means that all of this time, all of the public sector is being, or this, the government is being so sucked up arbitrating these claims. It's not great. The only people that are really benefiting from this are like lawyers. And that's not a great system. And it's not great for the employers. It's not great for the employees. It's not great for the wider public. So can we find something better? And they start to use, statistics and to try to, provide lawmakers the ability to justify making changes. And they end up going with workers' compensation, or as it was called at the time, workmen's compensation. Got to have that gendered thing at that point. Anyway, it's not super radical, though. It's not like completely revolutionary. These guys didn't think this up, nor did the other, dozen people that I could have put pictures up here in Wisconsin. Because, and in fact, outside of the United States, people were already establishing this. In England, or Britain, I would imagine, Great Britain, it's called the English system, I guess. But they start to change their laws starting in 1880 to address some of those shortcomings, to get away from the common law system or actually to continue using the common law system, but just, address some of the excesses. And ultimately, by 1897, they had basically a situation of workers' compensation insurance in play. Also in Germany, surprisingly, considering that this guy's in charge, the very conservative Otto von Bismarck, recognizes the benefit here and establishes a system. Now, in England and in Germany, there's a much more centralized sort of overview here. So they can, Otto von Bismarck, the chancellor can just say, this is the way it's going to be. I like this. And it just happens. A little harder in the United States, but there's precedent here. And particularly, a lot of the Germans who are emigrating to the United States, who are coming and making a life here, they have experience with workers' compensation and it works. So maybe we should start that. So in America, here's the interesting thing. There's a bunch of states that passed this. In Maryland in 1902, and I should say there's some before this point in the late 1800s. There's sort of a dissatisfaction of being like, ooh, this is embarrassing. Europe has their act together and we don't. So, but by 1900, we start to see a real push among, the progressives, so to speak, in the United States. So Maryland in 1902, Montana in 1908. In 1910, we have New York, which was kind of a particularly landmark one, and Wisconsin in 1911. Now, you might be wondering, wait, didn't you say that we had the oldest law system? And that we do, and that's because these three were struck down by the courts. They had basically tried to be a little ambitious and make it compulsory. This is the new system. It's going to completely replace the old system, which is the way that it is today. I think Texas is the only state and territory of the United States in which a company does not have to use workers' compensation. I could be wrong about that. But yeah, that's what happens. And so, and particularly in New York, it's a really tragic and radicalizing moment because the exact day after the court system strikes down workers' compensation, is the day that the Triangle Shirtwaist Factory fire happens. Now, if you're not familiar, this is one of the really, I put up a cartoon here because it gets the idea of what happened. Essentially, the employers had basically chained the doors to keep mostly women working in this factory there. So they couldn't leave. And that's what they would do, so nobody would be leaving. And then a fire happens and they were stuck inside, banging on the door as they were burning to death. And that's a horrible way to go. And this was just this moment of like, we need to do something about this. And it just so happened it was the day after they got rid of law that was intended to help these sort of people. So not ideal. But Wisconsin comes in next. And the thing that makes Wisconsin different is they make it so that you have to opt in. So instead of making it saying, here's this new insurance system, everybody needs to adopt it starting September 1st, they said, here's this new system, starting September 1st, you can opt in. And also worth noting, there were 9 other states that by the end of 1911 adopted similar laws that stood on the books. And within a decade, I think like 48 of the states in the United States had 46, 47, somewhere in there, had some version of workers' compensation insurance. So, yeah. But yeah, here is on May 4th, 1911, this article saying that, yeah, hey, Governor McGovern signed the law and it's going to become, signed the bill and it's going to become law in September. And that's, a landmark moment. Now, it's also worth noting that it's not like you had to wait until September 1st for a company to sell a policy. In fact, this is an article the day before the law becomes law of Wisconsin. And it points out that there are 55 companies who have elected to become under the new system, which basically meant that they had opted into workmen's compensation. And they note that there's a bunch of them. There's Ashland Brewing Company. There's a bunch of lumber companies. The Western Worsted Mills in Milwaukee, and Wausau Sulfate Fiber Company or Mosinee Paper in Mosinee. A bunch of different companies. So what makes Marathon County's experience the first? I think I'm not positive, but I think it's because they sold the policy the first under the new law, even before the creation, because they actually get started. Here's the company formally getting its articles of incorporation being filed on August 14th, and of course then they do issue the first. So that's kind of the trajectory here, which is really interesting. Now, it is worth noting that it's not like, hey, actually, I forgot to put this in. Well, I don't know if this is a fun fact, but a bit of trivia here. The first person to benefit from the new law in Marathon County was the wife or the widow of William Thrall, who worked for the Mosinee Paper Company. And in December, he was killed with an accident falling from a ladder. And so, hey, she now is getting paid. She was entitled to collect weekly the average wages earned by her husband until she has been paid the sum of $3,000. So, within a few months, we start to see people benefiting from the new system. Now, the story goes that in these early years, it was really tough until they hired Hans Hegge, who they brought in from Chicago to run the company. Not somebody who had any experience in insurance, but he learns the company and he kind of pivots and directs this company during some turbulent times. And I don't mean to say that he didn't do that at all. He absolutely did. It's a little unclear looking at the. Granted, these are newspaper articles from 1913, but very rosy outlook for them. Here's the annual report from the annual meeting where they basically were doing a couple $1 million adjusted for inflation. So they were in the black, unless they were maybe being creative in their reporting here. That's possible too. It's also possible that they just were the investors were not happy with the direction, that it wasn't making profit as quickly as they wanted, so they brought in Hans Hegge. But there is probably some difficulty here. Certainly, I don't think bringing in Hans Hegge magically fixed everything. I think it's a combination of the new management and people starting to recognize that the system is actually going to be useful. I think a lot of people were hesitant to go in the new system because they didn't need to. They could use the old system, and they didn't want to opt into this new workers' compensation thing, and then have it turned, challenged in the courts, and get invalidated within a year, like it had in all those other places. But after the courts, it works its way through the court system, and it's upheld as nope. This is constitutional. This is fine. Slowly, people start to do this, and ultimately, the company and the relationship here is actually is pretty good. Employers Mutual certainly does very well. This is their headquarters that they build in the 40s, which later becomes City Hall as they move up on the hill. And of course, they go on to do the depot ads and all of the advertising and lots of business. And a lot of the early. This isn't just the company does well selling insurance. It also fundamentally changes the relationship of workers and employers, because the common law system was really based on this idea of hey, who's at fault? We need to decide if the employer is at fault, if he's liable, or then pay the employee. Workers' compensation was, without regard to fault. It didn't matter whether it was unsafe condition or the worker was doing something, dangerous, or whether it was something completely else. That's not the point. Under this new system, now there's an incentive for everybody to do better, and it acknowledged the reality of the situation. In the old system, it was sort of like, hey, if somebody gets hurt at work, there's a fundamental failing. It should never happen to everybody. And ideally, it should never happen to anybody. But in the industrialized world that we are living in, the end of the 1800s, accidents are kind of an inevitable consequence. When you're working dangerous jobs, sometimes people are going to get hurt to some degree or another. So this new system basically takes that into understanding. Hey, we're not going to pretend that, fault is at blame here. As quote here, accidents were an inevitable consequence of the industrial system. So the industrial system should accept them as such and pay proper indemnities. And the insurance companies and the companies themselves that have policies and the workers and the employers, they all kind of realize that now everybody's in this together and we just need to be safe. And so this creates actually a much better working environment for a lot of the people. And you know, let's try to be safer, and let's not worry about whether, you know, trying to be safer makes the people in charge look bad or, you know, whatever. It's just something that's going to be good. And that has, you know, it's hard to know what would have happened without workers' compensation insurance, but it is arguably one of the big factors in making a safer world that we live in today. Um, yeah, that's a nice overview. You know, there's obviously a much more complicated thing. I tried to make it as, try not to get too much into the details of the legalese and all of that, but hopefully you learned something, enjoyed it, and yeah. Basically, what I wanted to do in, you know, this system, the idea of common law was something that I didn't really think about. And I thought maybe that would be interesting to see, like, why would we go about creating a new law? And sometimes it's based, you know, we need to address this new situation, but sometimes it's to just clarify. You know, actually, workers' compensation in Wisconsin is actually seen as somewhat of a conservative law. We don't think of it because it happened in the progressive era, but it was actually sort of like Charles McCarthy was saying, you know, hey, we need to do something about this before the socialists get their hands on it, because they're going to take it way too far, and we'll make this a way that's going to be better for everybody, for the, you know, business owners, and because you get the business owners on board, you know, things will work better. So it is a little bit more complicated than maybe we thought it was, or that I thought it was, and so yeah. Again, an example of some local government, you know, a civics lesson maybe, as evidenced through some local history. We're going to continue this topic. Like I said, the next few, so next week, Gary Gisselman will be in, and he'll be talking about what is a county board of supervisors? Who serves on it? How has that changed over Marathon County's history? And what do they do? Again, you might be aware of the County Board of Supervisors, but there's a longer history here. You know, hey, why not tune in and hear, you know, Alderman Gisselman tell us about the history of what that board is, and talk about that. And then throughout the rest of the month, we're going to be talking about, you know, what is a town versus a city, what is a municipality, and why would you want to go from one to the other? Something kind of, you know, very relevant right now with Rib Mountain wanting to become a village, or, you know, moving away from being a township, actively doing that. So, you know, hey, what is a town? What is a township? What is a village? What is a city? And all of that. And then we're going to round out the month with, what is a county code? What is the ruling law for the county? What is it? Where can you find it? And what is it? You know, I'm not entirely sure what I'm going to do for that, actually. We'll kind of dig into that together, and see what we can learn. So anyway, kind of a weird month here for programs, but you know, some interesting stuff, hopefully. Yeah. I'm just gonna look just to see if there's any comments or questions I'm missing here. If you're still watching, thanks. Wait, why is it doing that? Oh, there we go. Okay, yeah, so no, don't see any, that's all right. Like I said, thanks for watching. If you're still watching, it's an interesting topic. I know it's kind of a weird one, but yeah, hope you really enjoyed. Hopefully come back. And again, don't forget, we have some History Speaks coming up this weekend, and actually next month. I'll be talking more about some forms of public transportation, which I'm looking forward to digging in as well. So hopefully come back for all of that, if they're interest to you. And yeah, in the meantime, have a wonderful day, and we'll see you next time with some more history.